I was halfway through my morning coffee when I heard the knock that would turn my peaceful lakeside life into a legal nightmare. The woman at my door wore a cream-colored blazer despite the August heat in Coeur d'Alene, Idaho, and carried a leather portfolio that screamed trouble. Her name tag read Brenda Morrison, HOA president, and the tight smile on her face told me this wasn't a friendly welcome wagon visit. "Mr. Henry Owens?" she asked, though she clearly knew who I was. "That's me," I said, setting my mug down on the porch railing. "What can I do for you?" Brenda opened her portfolio with theatrical precision, pulling out a sheaf of papers. "I'm here to discuss a serious violation on your property. Your boathouse is in direct violation of our community's setback requirements. According to our current bylaws, all structures must maintain a minimum of 20 feet from the water's edge. Your boathouse sits approximately 8 feet from the shoreline." I stared at her, genuinely confused. "My boathouse? The one that's been here since before World War II? "That's irrelevant," she said crisply. "The violation exists regardless of when the structure was built. You have 30 days to either move the boathouse to comply with current regulations or demolish it entirely." The absurdity of her statement hit me like a cold wave. I'd bought this property 3 years ago specifically because of that boathouse. It was a beautiful piece of craftsmanship from 1920, built by the original homeowner who'd constructed it right at the water's edge, as was common practice back then. The thing was a historical gem with hand-hewn cedar beams and original hardware. "You can't be serious," I said. "That boathouse is over 100 years old. It was built decades before this HOA even existed." Brenda's expression didn't change. "The age of the structure doesn't grant it immunity from current regulations. This community values order and uniformity. Every homeowner must comply with the same rules." "When did this HOA even form?" I asked, my irritation rising. "The Pine Lake Estates Homeowners Association was established in 2003, she said proudly. "We've worked hard to maintain property values and aesthetic standards in this community." "So you formed an HOA 83 years after my boathouse was built, and now you want me to tear it down because it doesn't meet your modern standards?" "I understand your frustration, Mr. Owens, but rules are rules. You received a copy of the CC and Articus when you purchased your property. Ignorance of the regulations isn't an excuse." I remembered those documents vaguely. They'd been part of a massive stack of closing paperwork, and my attorney had assured me everything was standard. I'd been more focused on the house itself and the stunning view of Lake Coeur d'Alene than on reading hundreds of pages of HOA bylaws. "I want to see where this setback rule is written," I said. "And I want to understand how you think you can enforce it on a structure that predates your organization by 8 decades. Brenda pulled out another document. Article 7, Section 3, Subsection B. "All accessory structures including but not limited to sheds, garages, gazebos, and boathouses must maintain minimum setbacks of 20 feet from water features. No exceptions." "No exceptions," I repeated. "That's convenient, Mr. Owens. I'm trying to be reasonable here. You have 30 days to come into compliance. If you fail to do so, the association will be forced to take legal action. The fines start at $500 per day." The number made my stomach drop. $500 per day would bankrupt me in a matter of weeks. This is extortion. "This is enforcement of community standards," Brenda said, her voice hardening. "I suggest you consult with a contractor about your options. Good day." She turned and walked back to her white Lexus, leaving me standing on my porch with a growing sense of dread. I picked up my coffee, but it had gone cold. The next few days were a blur of phone calls and research. I contacted 3 different contractors about the possibility of moving the boathouse. Every single one told me the same thing. The structure was too old and fragile to relocate. Moving it would likely destroy it. Demolition was the only realistic option if I had to comply with the setback requirement. But something about Brenda's ultimatum didn't sit right with me. I'd always been the type to research things thoroughly, which is probably why I'd ended up as a freelance technical writer. I could spend hours digging through documentation and making sense of complex systems. Now, I turned those skills toward understanding property law and HOA regulations in Idaho. What I discovered was fascinating and infuriating in equal measure. Idaho law did provide some protections for pre-existing structures through what's called grandfathering or legal non-conforming use. Essentially, if a structure was legally built before new regulations came into effect, it could continue to exist even if it didn't meet current standards. The catch was proving that the structure had been legally built in the first place. I needed documentation. The boathouse had been built in 1920, which meant I needed records from over a century ago. I started at the Kootenai County Assessor's office, requesting any historical records related to my property. The clerk, a friendly woman named Patricia, seemed genuinely interested in my predicament. "HOA trouble?" she asked sympathetically. "We get a lot of those requests these days. They want me to tear down a boathouse that's been here since 1920, I explained. Patricia's eyebrows rose. 1920? That's before most of the building codes even existed in this area. Let me see what I can find. She disappeared into a back room and returned 20 minutes later with a dusty box of files. You're in luck. We have property records going back to the original land grant. Your parcel was first developed in 1919 by a man named Thomas Whitmore. He built the main house and several outbuildings in 1920. We spread the documents across a table. There were hand-drawn property surveys, tax records, and even some original photographs. One black and white image showed my boathouse in pristine condition, with a vintage wooden boat moored inside. The photograph was dated June 1921. "This is perfect," I said. "This proves the boathouse has been there for over 100 years. "There's more," Patricia said, pulling out another document. "Here's the original building permit from 1920. Back then, they weren't as detailed as modern permits, but it clearly shows approval for a boat storage structure at the water's edge." I felt a surge of hope. This was exactly what I needed. "Can I get copies of all of this?" "Absolutely. Give me about an hour and I'll have everything scanned and printed for you." While I waited, I called my buddy Marcus, who happened to be a real estate attorney in Spokane. We'd known each other since college, and he'd helped me with the original purchase of the property. I explained the situation and what I'd found at the assessor's office. "Henry, this is textbook grandfathering," Marcus said. "If you can prove the structure was legally built before the HOA regulations came into effect, they can't force you to tear it down. Idaho code specifically protects legal non-conforming structures. Even though I bought the property after the HOA was formed, doesn't matter. The protection runs with the land, not the owner. You inherited the grandfathered status when you bought the property. The HOA should have disclosed this before making threats. So what do I do now? Send them a formal response with copies of your documentation. Cite Idaho Code Title 55, Chapter 19. That's the statute governing non-conforming uses. Make it clear that you're aware of your rights and that their attempt to enforce the setback requirement is legally invalid." I thanked Marcus and hung up feeling considerably better. Patricia returned with a thick folder of copies, and I spent the evening organizing everything into a comprehensive response to the HOA. My letter to Brenda Morrison was polite but firm. I outlined the history of the boathouse, provided copies of the 1920 building permit and historical photographs, and cited the relevant Idaho statutes protecting legal non-conforming structures. I concluded by requesting that the violation notice be withdrawn immediately. I sent the letter via certified mail and waited. 3 days later, I received a response that made my blood boil. Instead of acknowledging the evidence, Brenda doubled down. Her letter claimed that the 1920 building permit was potentially fraudulent and that the photographs could have been taken anywhere. She demanded that I hire an independent historian to verify the documents at my own expense, and she reduced my compliance deadline from 30 days to 15. "Are you kidding me?" I said aloud to my empty kitchen. I called Marcus again. "They're not backing down. In fact, they're escalating." "Then we escalate too," Marcus said. "File for declaratory relief with the district court. We'll ask the judge to declare that your boathouse is a legal non-conforming structure and that the HOA's violation notice is invalid." "How much is this going to cost me?" Marcus was quiet for a moment. "I can probably handle the filing for around $5,000 up front. If it goes to trial, we're looking at $20,000 to $30,000 potentially." The number made me dizzy. I wasn't wealthy by any means. My freelance writing income was decent, but I didn't have tens of thousands lying around for legal fees. Still, the alternative was losing the boathouse and potentially paying hundreds of thousands in HOA fines. "Let's do it," I said. The next 2 weeks were among the most stressful of my life. Marcus filed the complaint in Kootenai County District Court, and we served notice to the HOA. Brenda's response was swift and aggressive. The HOA hired a law firm out of Boise, and their attorney, a man named Richard Keller, filed a motion to dismiss our case. Their argument was technical but basically claimed that I'd waived my right to challenge the HOA regulations by purchasing property within their jurisdiction. They also argued that even if the boathouse was grandfathered, it had been substantially modified over the years, which invalidated its non-conforming status. That last claim was pure fabrication. I'd done nothing to the boathouse except basic maintenance and a fresh coat of paint. But defending against false claims still required time and money. Marcus advised me to hire a structural engineer to inspect the boathouse and document its original features. I found a firm in Spokane that specialized in historical structures. The lead engineer, a detail-oriented woman named Dr. Sarah Chen, spent an entire day examining every beam, joint, and nail in the boathouse. Her report was thorough and unequivocal. "This structure retains approximately 95% of its original materials and design," she wrote. "The only modifications appear to be routine maintenance items, such as roof repairs and paint application. The fundamental structure, including all primary load-bearing elements, remains as originally constructed in 1920. We submitted Dr. Chen's report to the court, along with affidavits from 3 local historians, who verified the authenticity of the 1920 photographs and building permits. I thought we had an airtight case. Then Brenda played her trump card. I arrived home one afternoon to find a group of people on my property. Brenda was there, along with a man in a suit carrying surveying equipment and 2 others I didn't recognize. They were taking measurements of my boathouse and the distance to the water. "What are you doing on my property?" I demanded. Brenda turned with that same tight smile. "The HOA has the right to inspect properties for compliance verification. It's in the CC and Articus." "Get off my land," I said. "You don't have permission to be here." The man in the suit approached me. "Mr. Owens, I'm David Fletcher, a licensed surveyor." The HOA has hired me to conduct an independent survey of your boathouse location. This will only take a few more minutes. I don't care if it takes 5 seconds. You're trespassing." Brenda's smile vanished. "Mr. Owens, you're being unreasonable. We're simply gathering evidence for the court case. You're only making yourself look worse." I pulled out my phone. "I'm calling the sheriff. You have 60 seconds to get off my property." David Fletcher quickly packed up his equipment. "We have what we need anyway," he said. They left, but the damage was done. 2 days later, the HOA filed a supplemental brief with the court that included Fletcher's survey. According to his measurements, my boathouse was actually only 6 feet from the water's edge, not 8 as originally claimed. They argued this proved the structure was even more out of compliance than initially stated. What they didn't mention was that the water level in Lake Coeur d'Alene fluctuates seasonally. The survey had been taken in late August when the lake was at its highest level. In winter, the waterline recedes by several feet. Their survey was deliberately misleading. Marcus immediately filed a motion to strike the survey as evidence, arguing it had been obtained through improper access to my property. The judge, a stern-looking man named Howard Renfrew, scheduled a hearing to address the multiple motions flying back and forth. The hearing was set for September 15th. I spent the intervening weeks feeling like I was living under siege. Brenda began showing up at neighborhood events and talking to other homeowners about my defiance of HOA regulations. She painted me as a troublemaker who thought he was above the rules. Several neighbors stopped speaking to me. A few even left hostile notes in my mailbox. One read, "Just tear down the damn boathouse and stop causing problems for everyone." Another said, "You don't own the lake. Follow the rules like everyone else." But not everyone turned against me. My next-door neighbor, Tom Harrison, was a retired contractor who'd lived in the area for 30 years. He knocked on my door one evening with a 6-pack of beer and a sympathetic ear. "Brenda pulled this same garbage with the Mitchells 3 years ago," Tom said. They had a garden shed that was supposedly 2 inches over the property line. The HOA fined them into submission until they moved it. "Why does she care so much?" I asked. Tom shrugged. "Power trip, mostly. Brenda moved here from California about 5 years ago. She got elected HOA president and decided to make a name for herself by strict enforcement. She thinks it raises property values, but mostly it just makes everyone miserable. Has anyone ever fought back? Not successfully. Most people can't afford the legal fees. The HOA has deep pockets because of all those monthly dues. They can drag things out until people give up." "I'm not giving up," I said. "This boathouse is worth fighting for." Tom clinked his beer bottle against mine. "Good for you. Let me know if you need anything. I've got some connections in the county government if that helps." The hearing arrived faster than I wanted. Marcus and I met at the courthouse early, going over our arguments one last time. The courtroom was smaller than I expected, with maybe 20 seats for observers. Brenda was there with her attorney, Richard Keller, a slick-looking guy in an expensive suit. A few other HOA board members sat behind them. Judge Renfrew took his seat and immediately got down to business. "We're here to address multiple motions in the case of Owens versus Pine Lake Estates Homeowners Association. Let's start with the defendant's motion to dismiss." "Mr. Keller." Richard Keller stood and launched into a practiced speech about HOA authority and member obligations. He argued that I'd voluntarily joined the HOA by purchasing property within its jurisdiction, and that I was bound by its rules. The age of the boathouse was irrelevant because the rules applied equally to all structures. Judge Renfrew listened impassively, occasionally making notes. When Keller finished, The judge turned to Marcus. "Counselor." Marcus stood and presented our case methodically. He explained the concept of legal nonconforming use, provided the historical documentation, and cited multiple Idaho cases where courts had protected grandfathered structures. He also pointed out that the HOA's own CC and Articus contained a provision acknowledging that pre-existing conditions might not comply with current standards. The HOA is attempting to retroactively enforce regulations on a structure that predates their organization by 83 years, Marcus said. This is precisely the type of situation that grandfathering provisions were designed to prevent. The boathouse was legally built in 1920. It has not been substantially modified. It is entitled to protection under Idaho law. Keller objected repeatedly, but Judge Renfrew waved him off. "I'll hear your rebuttal in a moment, counsel." After Marcus finished, we addressed the survey issue. Marcus argued that the HOA's unauthorized entry onto my property violated my Fourth Amendment rights, and that any evidence gathered should be excluded. Keller countered that the HOA had explicit authority to inspect properties under the CC and Articus. Mr. Owens signed a contract giving the association reasonable access for compliance purposes. "There's nothing reasonable about trespassing when the owner explicitly objects," Marcus shot back. The HOA could have sought a court order if they truly believed inspection was necessary. Instead, they engaged in self-help that violated my client's property rights. Judge Renfrew held up his hand. "Gentlemen, I've heard enough for today. I'm going to take these motions under advisement. You'll have my ruling within 2 weeks." We filed out of the courtroom. Brenda approached me in the hallway and I braced for another confrontation. "Mr. Owens, this doesn't have to be so difficult," she said. "The board has discussed your situation and we're willing to offer a compromise." "What kind of compromise?" "We'll allow the boathouse to remain if you agree to screen it with landscaping so it's not visible from the lake. We'll also require a structural inspection every 2 years to ensure it remains safe. You'll be responsible for all costs." I looked at Marcus, who gave a slight shake of his head. "I'll think about it," I told Brenda. "Don't think too long," she said. "The offer expires when the judge rules." Back in Marcus's office, we discussed the proposal. "It's a trap," he said. "If you accept their compromise, you're acknowledging they have authority over the boathouse. Plus, requiring biannual inspections at your expense is just a way to nickel and dime you into compliance." "That's what I thought," I said. "We stick with the lawsuit." The 2 weeks waiting for Judge Renfrew's decision felt like 2 years. I threw myself into work, taking on extra projects to cover mounting legal bills. Every time my phone rang, I jumped, thinking it might be Marcus with news. The call finally came on September 28th. "The judge denied their motion to dismiss," Marcus said, and I could hear the smile in his voice. "He also granted our motion to exclude the survey evidence. This is good, Henry, really good." "So what happens now?" "Now we go to trial. The judge wants to hear full arguments on the merits." He scheduled us for November 3rd. November 3rd. That gave us 5 weeks to prepare. Marcus explained that we'd need to present our evidence formally, including calling witnesses to testify about the boathouse's history and legal status. "I'm going to subpoena the county records," Marcus said. "And I want Dr. Chen to testify about the structural inspection. Do you think you can find anyone who remembers the boathouse from decades ago?" That seemed like a long shot, but I decided to try. I posted on local Facebook groups and the Coeur d'Alene Historical Society's message board, asking if anyone had information about boathouses built in the 1920s on Lake Coeur d'Alene. The responses surprised me. Within a week, I'd heard from a dozen people with connections to the area's history. One woman, Martha Kincaid, said her grandfather had been friends with Thomas Whitmore, the original builder of my property. She had family photographs from the 1920s and 1930s that showed various properties around the lake, including mine. I met Martha at a coffee shop in downtown Coeur d'Alene. She was in her 70s, sharp as a tack and clearly delighted to talk about local history. She spread a collection of photographs across our table. "This is your boathouse in 1922, she said, pointing to a clear image. "My grandfather and Thomas Whitmore used to go fishing together. Grandpa always said Thomas built the finest boathouse on the lake." The photograph showed two men standing in front of my boathouse, holding up a string of fish. The structure looked almost identical to how it appeared now, just newer. "Would you be willing to testify in court?" I asked. "To verify these photographs and explain your family's connection to the property." Martha's eyes lit up. "I'd be honored. Anything to help preserve a piece of our local history." I left the coffee shop with copies of Martha's photographs and a renewed sense of hope. Marcus was thrilled when I showed him the new evidence. "This is exactly what we need," he said. "Contemporary photographs from multiple sources, plus witness testimony linking them directly to your property. The HOA won't be able to claim these are generic images." As the trial date approached, Brenda escalated her campaign against me. She organized a special HOA meeting to discuss the problem of non-conforming structures and invited a speaker from a property management company to talk about maintaining community standards. The whole thing was obviously aimed at turning residents against me. I decided to attend the meeting. Marcus advised against it, but I felt like I needed to defend myself publicly. The meeting was held at the community clubhouse, a modern building near the entrance to our neighborhood. About 40 residents showed up, filling most of the available chairs. Brenda began with her usual speech about property values and community harmony. Then she introduced the guest speaker, a man named Gerald Priest who ran a property management firm in Boise. Gerald launched into a PowerPoint presentation about the importance of architectural consistency and how allowing exceptions undermined HOA effectiveness. "Every community has that one resident who thinks the rules don't apply to them," Gerald said, and I felt every eye in the room turn toward me. "These individuals create chaos and force the association to spend time and money on enforcement. The solution is simple, no exceptions, ever." When he finished, Brenda opened the floor for questions. I raised my hand immediately. "Mr. Owens," Brenda said coldly, "I'm surprised to see you here." "I live here," I said, "and I think the residents deserve to hear both sides of this issue." Murmuring ran through the crowd. Brenda's lips pressed into a thin line. "You'll have your chance to speak in court." "I'm speaking now," I said, standing up. "The boathouse everyone is so concerned about was built in 1920. It's a piece of this area's history. It was legally constructed decades before this HOA existed. I have original building permits, historical photographs, and witness testimony proving all of this. The HOA is trying to destroy something historically significant because it doesn't fit their arbitrary standards." "Those standards exist for a reason," Brenda shot back. "They protect all of our property values. Do they? Or do they just give you power to bully your neighbors?" The room erupted in competing shouts. Some people supported me, others defended Brenda. Tom Harrison stood up from the back. "I've lived here longer than almost anyone, and I remember when this neighborhood was about community, not rules. That boathouse has been there my entire life. Tearing it down would be a damn shame." "Thank you, Tom," Brenda said icily. "But this isn't a democracy. The board makes decisions based on the CC and Artiques, not popular opinion." Another resident, a younger woman named Jennifer, raised her hand. I bought my house 6 months ago, and the boathouse was one of the things I loved about the neighborhood. It has character. If I wanted cookie-cutter suburban conformity, I would have bought in a different development. More voices joined in, and I realized the room was split almost evenly. Brenda tried to regain control, but the meeting devolved into argument. Finally, she adjourned everything early, clearly frustrated. As people filed out, several residents approached me with words of support. A few exchanged contact information, saying they'd be willing to sign a petition or submit statements to the court. It wasn't a complete victory, but it felt like progress. The weeks leading up to trial were intense. Marcus and I met repeatedly to prepare testimony and organize evidence. We created a timeline showing the boathouse's construction in 1920, the formation of the HOA in 2003, and my purchase of the property in 2021. The point was to demonstrate that the boathouse had existed legally for over a century before the HOA tried to enforce its rules. Dr. Chen prepared detailed diagrams of the boathouse's construction, highlighting original materials and showing how little had changed over the decades. Martha Kincaid organized her family photographs chronologically and prepared written notes about her grandfather's relationship with Thomas Whitmore. We also subpoenaed Patricia from the assessor's office to testify about the authenticity of the county's historical records. Marcus explained that having a government employee verify the documents would carry significant weight with the judge. The HOA wasn't idle either. They hired their own structural engineer who claimed that the boathouse showed signs of substantial modification that invalidated its grandfathered status. Their engineer's report was thin on specifics but heavy on conclusions. Marcus called it a hired gun opinion and wasn't worried about it. More concerning was Brenda's witness list. She'd found 3 residents willing to testify that the boathouse was an eyesore that hurt property values. One of them, a real estate agent named Karen Dempsey, claimed that potential buyers had expressed concerns about old, poorly maintained structures in the neighborhood. I'd never spoken to Karen, but I'd seen her around. She was exactly the type Brenda would recruit. Middle-aged, perfectly coiffed, with the pinched expression of someone who found fault with everything. Her testimony would be problematic because she had professional credentials in real estate. Marcus and I prepared a strategy to undermine Karen's credibility. We requested documentation of any specific buyers who'd complained about the boathouse, knowing she probably couldn't provide any. We also planned to point out that my property value had actually increased since I purchased it, according to county assessment records. The night before trial, I barely slept. I kept running through scenarios in my head, imagining questions from the judge or Keller's cross-examination. Marcus had prepared me as much as possible, but there was no way to know how things would actually unfold. The morning of November 3rd arrived cold and gray. I met Marcus at the courthouse at 8:30 for a 9 o'clock start time. The courtroom was more crowded than I expected. Tom Harrison was there, along with Jennifer and several other neighbors who'd spoken up at the HOA meeting. Brenda sat at the defendant's table with Keller and 2 other HOA board members. Judge Renfrew entered and we all stood. "Please be seated," he said. "We're here for trial in the matter of Owens versus Pine Lake Estates HOA. This is a bench trial, so I'll be deciding the facts and the law. Counsel, are you ready to proceed?" Both Marcus and Keller confirmed they were ready. The judge nodded to Marcus. "Plaintiff may present his opening statement." Marcus stood and approached the podium. "Your Honor, this case is about whether a homeowners association can retroactively enforce modern regulations on a structure built over a century ago." The evidence will show that Mr. Owens's boathouse was legally constructed in 1920, decades before the defendant HOA even existed. The boathouse has historical and architectural significance. It has not been substantially modified. Under Idaho law, it is entitled to protection as a legal non-conforming use. The HOA's attempt to force demolition or relocation is legally invalid and should be rejected. Keller's opening was more theatrical. He paced in front of the judge's bench, gesturing broadly. "Your Honor, this case is about whether one homeowner can ignore community standards that everyone else follows. Mr. Owens bought property in an HOA-governed community. He agreed to follow the rules. Those rules exist to protect property values and maintain aesthetic consistency. The age of Mr. Owens's boathouse is a red herring. The real question is whether the rules apply to everyone or whether some people get special treatment." Judge Renfrew made notes but gave no indication of his thinking. "Call your first witness, Mr. Wilson," he told Marcus. Our first witness was Patricia from the county assessor's office. Marcus walked her through the historical records, having her authenticate the 1920 building permit and property surveys. Patricia was professional and clear, explaining how the county maintained records and verifying that everything in our documentation was genuine. Keller's cross-examination tried to raise doubts about the reliability of century-old documents. "Isn't it possible these records could be mistaken?" he asked. "Anything is possible," Patricia replied calmly, "but these records have been maintained continuously by the county for over 100 years. There's no reason to doubt their accuracy. Could someone have fabricated a building permit and inserted it into county files?" Patricia looked offended. "Absolutely not. Our records are carefully controlled. What you're suggesting would be a serious crime." Keller backed off, realizing he was alienating the witness. Next, we called Dr. Chen, the structural engineer. She presented her findings methodically, using photographs and diagrams to show the boathouse's original construction. She explained that 95% of the materials were original and that the only changes were routine maintenance items. "In your professional opinion, has this structure been substantially modified?" Marcus asked. "No," Dr. Chen said firmly. "This boathouse remains essentially as it was built in 1920. It's actually a remarkable example of preservation." Keller's cross-examination focused on the 5% of materials that had been replaced. "So you admit that modifications have been made?" "I wouldn't characterize replacing a few damaged roof shingles as modification in any meaningful sense," Dr. Chen said. "We're talking about maintenance necessary to preserve the original structure. But changes were made to the original design." "No, the design remains identical. Some materials have been replaced with matching materials to prevent deterioration. That's preservation, not modification." Martha Kincaid was our final witness, and she was perfect. She described her grandfather's friendship with Thomas Whitmore and authenticated the family photographs showing the boathouse in the 1920s and 1930s. She spoke with warmth about the area's history and the importance of preserving structures like my boathouse. "These old buildings tell the story of our community," Martha said. "They connect us to our past. Losing them would be tragic." Keller barely cross-examined her. There was nothing to attack in her testimony. The photographs were genuine, her family connection was well documented, and her credibility was unimpeachable. Then it was the HOA's turn to present their case. Their first witness was David Fletcher, the surveyor who'd measured the boathouse. He presented his findings that the structure was only 6 feet from the water's edge. Marcus's cross-examination was devastating. "Mr. Fletcher, when did you take these measurements?" August 26th of this year. What was the water level of Lake Coeur d'Alene on that date? Fletcher hesitated. I didn't specifically note the water level, but you're aware that the lake level fluctuates seasonally. Yes. And August is typically when the lake is at its highest level, correct? Generally, yes. So your measurements represent the minimum distance between the boathouse and the water, not the typical distance. Fletcher shifted uncomfortably. The measurements are accurate for the date they were taken, but misleading if presented as the standard distance. Wouldn't you agree? I suppose it depends on how you define standard. Marcus pulled out a chart showing Lake Coeur d'Alene's water levels over the past decade. According to historical data, the lake level on August 26th was approximately 2 feet higher than the annual average. If you'd taken your measurements during an average water level period, the boathouse would have been approximately 8 feet from the shoreline, correct? Fletcher studied the chart. That would be consistent with the data, yes. So the HOA's claim that Mr. Owens's boathouse is only 6 feet from the water is, at best, misleading. The measurement is accurate for the specific date, but not representative of typical conditions. Thank you, Mr. Fletcher. No further questions. The HOA's structural engineer was next, a man named Paul Hendricks who worked for a firm in Boise. His testimony about substantial modifications fell apart under Marcus's cross-examination. Mr. Hendricks, did you personally inspect Mr. Owens's boathouse? No, I reviewed photographs and documentation provided by the HOA. So your conclusions are based entirely on second-hand information. I relied on the documentation provided to me. Did that documentation include Dr. Chen's engineering report? Hendricks hesitated. I don't believe so. So you formed your opinion without reviewing the detailed structural analysis prepared by an engineer who actually inspected the property. I worked with the information I had. Marcus introduced Dr. Chen's report into evidence. Mr. Hendricks, does this report indicate substantial modification to the boathouse? Hendricks skimmed through it. This report suggests minimal changes to the original structure. In fact, Dr. Chen concluded that 95% of the materials are original, correct? That appears to be her conclusion, yes. You have any basis to dispute that finding? Without conducting my own inspection, I can't say definitively. So your testimony about substantial modifications is speculation based on incomplete information, Judge Renfrew interrupted. Mr. Wilson, I think you've made your point. Move on. Karen Dempsey was the HOA's final witness, and she was everything I expected. She testified that old structures like my boathouse hurt property values and made the neighborhood less desirable to potential buyers. Marcus let her talk, giving her plenty of rope. Then he started his cross-examination. Miss Dempsey, can you provide specific examples of buyers who declined to purchase property in Pine Lake Estates because of Mr. Owens's boathouse? I can't share client information, Karen said. I'm not asking for names. I'm asking if any such buyers actually exist. Karen's face flushed. Buyers express concerns about neighborhood aesthetics all the time. But have any specifically mentioned Mr. Owens's boathouse? Not in those exact words, no. In any words. The concerns are more general. So you have no evidence that Mr. Owens's boathouse has negatively impacted any property sales. It's the type of structure that could impact sales. Could, but you have no evidence that it has. No specific evidence, no. Marcus pulled out property records. Miss Dempsey, are you aware that property values in Pine Lake Estates have increased by an average of 12% over the past 3 years? I'd need to verify those numbers. These are county assessment records. And according to these records, Mr. Owens's property has increased in value by 15% since he purchased it in 2021. Does that sound like a property negatively impacted by an old boathouse? Karen didn't answer directly. Property values are influenced by many factors. Indeed they are. And clearly the boathouse isn't hurting Mr. Owens's property value. No further questions. Both sides presented closing arguments. Keller made a passionate appeal about community standards and the importance of HOA authority. Marcus methodically reviewed the evidence and emphasized that the law protected grandfathered structures regardless of HOA preferences. Judge Renfrew thanked everyone and said he'd issue a written decision within 30 days. We filed out of the courtroom exhausted but cautiously optimistic. "I think we won," Marcus said, "but you never know for sure until the judge rules." The waiting was agonizing. November turned into December and still no decision. Marcus assured me this was normal, but every day felt like an eternity. Brenda continued to glare at me whenever we crossed paths in the neighborhood, but she didn't approach me or send any more letters. On December 18th, Marcus called. "We have a decision. Can you come to my office?" I drove to Spokane in record time. Marcus was grinning when I walked into his office. "We won. Complete victory." He handed me a copy of Judge Renfrew's decision. It was 23 pages long, but the conclusion was clear. The boathouse was a legal non-conforming structure protected under Idaho law, and the HOA had no authority to force its removal or modification. The judge's reasoning was thorough. He found that the boathouse was indisputably built in 1920 under a valid building permit. He noted that the structure had not been substantially modified over the past century. He explained that legal non-conforming status protected the boathouse from retroactive enforcement of HOA regulations adopted decades after its construction. Judge Renfrew also criticized the HOA's conduct. He wrote that the organization had overstepped its authority and failed to acknowledge well-established principles of property law. He ordered the HOA to withdraw its violation notice and prohibited them from taking any further action against the boathouse based on setback requirements. Most surprisingly, the judge ordered the HOA to pay my attorney's fees, finding that their position had been objectively unreasonable given the clear applicability of grandfathering protections. "How much are we talking about?" I asked Marcus. "With the fees for the trial and all the pre-trial work, probably around $40,000. The HOA is going to have to cut you a check." I felt lightheaded. Not only had I won, but I wasn't going to be bankrupted by legal fees. It was better than I dared hope. The decision became public the next day, and reactions in the neighborhood were mixed. Some people congratulated me, saying they'd been rooting for me all along. Others remained hostile, viewing me as a troublemaker who challenged community authority. Tom Harrison brought over a bottle of bourbon to celebrate. "You did it," he said, raising his glass. "You took on Brenda and won." "I just defended my property," I said, "but thank you for supporting me through all this. Someone needed to stand up to her." Maybe this will make the HOA think twice before bullying people. That turned out to be wishful thinking. Brenda sent a terse email to all residents acknowledging the court decision, but insisting that the HOA would continue to enforce community standards vigorously. She made no apology for the way she'd handled my situation. The HOA's attorney, Richard Keller, filed a notice of appeal 2 weeks later. Marcus wasn't surprised. "They're just going through the motions," he said. "The legal issues are clear, and appellate courts rarely overturn decisions like this." But filing an appeal lets Brenda save face with the board. The appeal process dragged on through the winter and into early spring. I tried to put the whole thing out of my mind and focus on enjoying my property. The boathouse looked beautiful covered in snow, and I spent several evenings sitting inside it with a space heater, watching the frozen lake and feeling grateful that the structure had survived. In March, the Idaho Court of Appeals issued a brief order affirming Judge Renfrew's decision. They found no legal error and declined to address the HOA's arguments in detail. Marcus said this was actually good news because it meant the appeals court thought the case was straightforward. The HOA had 30 days to petition the Idaho Supreme Court for further review, but that deadline passed without any filing. The case was finally, definitively over. The HOA sent me a check for $42,000 in attorney's fees in early May. I split it with Marcus according to our fee agreement, leaving me with a small profit after covering my portion of the costs. More importantly, the boathouse was safe, but the story wasn't quite finished. In June, I received a letter from a woman named Elizabeth Carmichael who lived in Seattle. She explained that she was a great-granddaughter of Thomas Whitmore, the original builder of my property. She'd read about the lawsuit in a local history blog and wanted to thank me for preserving her great-grandfather's work. "My family has very few physical reminders of Thomas," she wrote. "Knowing that his boathouse still stands means a great deal to us. If you're ever willing to show it to me, I'd love to visit." I invited Elizabeth and her family to visit in July. She came with her husband and 2 teenage daughters. We spent an afternoon exploring the boathouse and the property, and Elizabeth shared stories about Thomas Whitmore that I'd never heard. "He was a master carpenter," she said, running her hand along one of the cedar beams. "He believed in building things to last. I'm so glad you fought to protect this." Her daughters took dozens of photographs, documenting every detail of the boathouse's construction. Elizabeth explained that her family was creating a historical archive about Thomas Whitmore, and my boathouse would be a centerpiece. Before they left, Elizabeth gave me a framed photograph from 1920 showing Thomas Whitmore standing in front of the newly completed boathouse. "I want you to have this," she said. "You've earned it." I hung the photograph in my living room where I could see it every day. It reminded me why the fight had been worth it. The conflict with the HOA had lasting effects on the neighborhood. Brenda ran for re-election as HOA president that fall and lost decisively. Several residents who'd been inspired by my case ran for board positions on a platform of reasonable enforcement, and won. The new board revised the CC and Articus to explicitly recognize grandfathered structures and to require more careful legal review before pursuing enforcement actions. Karen Dempsey, the real estate agent who testified against me, found herself under scrutiny. Several residents filed complaints about her testimony, arguing she'd misrepresented market conditions. While nothing official came of it, her reputation in the neighborhood was damaged, and she quietly moved her business focus to other areas. As for me, I settled into peaceful enjoyment of my property. I restored a vintage wooden boat and kept it in the boathouse, just as Thomas Whitmore had done a century ago. I started a blog about local history, featuring stories about Lake Coeur d'Alene and the people who'd built the communities around it. Tom Harrison became a good friend, and we spent many summer evenings fishing from my dock, the boathouse standing sentinel behind us. He'd often remark on how much better the neighborhood felt without Brenda's constant surveillance and enforcement threats. The boathouse itself became something of a local landmark. The Historical Society featured it in a walking tour of significant structures around the lake. A photographer from the Coeur d'Alene Press did a feature story about historic boathouses, and mine was prominently featured. I received several offers from people wanting to buy my property specifically because of the boathouse. One developer offered substantially above market value, planning to tear down the house and boathouse to build a modern mansion. I declined without hesitation. Some things aren't for sale. The legal battle taught me important lessons about standing up for what matters and not letting bullies, even institutional ones, push you around. It also taught me about the importance of historical preservation and respecting the work of people who came before us. Every time I look at that boathouse, I think about Thomas Whitmore spending weeks in 1920 cutting and fitting those cedar beams. I think about the care he took to build something beautiful and functional. I think about the century of storms and seasons the structure has weathered, standing strong at the water's edge. And I think about Brenda Morrison showing up at my door with her leather portfolio and tight smile, confident that she could force me to destroy something irreplaceable. I think about the moment when she realized that her authority had limits, that there were principles more important than uniform setbacks and community aesthetic standards. The boathouse stands today exactly as it stood in 1920, a testament to quality craftsmanship and to the idea that some things are worth fighting for. When I sit inside it on quiet evenings, listening to the water lap against the supports, I feel connected to a history larger than myself. I preserved something that matters, not just for me but for everyone who values continuity and respect for the past. In the end, the HOA's aggressive enforcement attempt backfired completely. They spent tens of thousands of dollars pursuing a losing case, damaged their reputation in the community, and ultimately had to acknowledge that their authority wasn't unlimited. The new board operates with much more humility and common sense, recognizing that blanket enforcement of rules without consideration of context and history serves no one's interests. I still live in Pine Lake Estates, and I'm still technically a member of the HOA, though I keep my interactions with them minimal. The monthly dues go toward maintaining common areas and organizing community events, which is fine. But I'll never forget the months of stress and uncertainty when it seemed like I might lose something precious because of arbitrary regulations and one person's power trip. The boathouse has become more than just a structure to me. It represents resilience and the importance of knowing your rights. It represents the value of historical preservation and the beauty of traditional craftsmanship. Most of all, it represents the simple truth that sometimes you have to fight for what matters, even when the odds seem stacked against you. On summer mornings, I take my coffee down to the boathouse and sit on the small deck Thomas Whitmore built. The same sun that lit his work in 1920 lights mine today. The same water that lapped at the supports then laps at them now. There's something profound in that continuity, something worth protecting. The lawsuit over my boathouse taught me that communities function best when they balance rules with reason, when they respect history while planning for the future, and when they remember that the goal of regulation should be to enhance life, not to impose uniformity for its own sake. Brenda Morrison learned that lesson the hard way at the cost of $42,000 and her position as HOA president. I learned it through months of stress and uncertainty that ultimately led to victory. The boathouse itself learned nothing, of course. It just stood there through it all, solid and unchanging, exactly as Thomas Whitmore built it over a century ago. And with any luck, it will stand there for another century to come, a small piece of history preserved against the forces that would erase it.